Good afternoon, good evening, or indeed to those of you who are starting to join us from across the Atlantic, good morning. My name is James Pickavance. I'm a partner at Jones Day, based here in London, and this is the afternoon session of the International Construction Law Conference. We've been thrilled with the attendance and indeed the content of the morning sessions. We have had upwards of 2,000 people joining us, and indeed the acceptance list for the event itself is just shy of 3,500. And to give you some perspective on that, that would fill the Royal Albert Hall. So we're thrilled with the opportunity that this platform presents. This afternoon session is entitled New Technology Equals Fewer Disputes. This panel will look at how advances in technology and construction projects might impact the nature and extent of disputes arising on projects and how they are litigated. Emma Schaafsma will chair this session. She is a partner at the International Construction Disputes practice of Herbert Freehills. Up until last year, Emma was based in Tokyo and led HSF's construction disputes team there, acting for Japanese clients on complex and high-value litigation and arbitrations arising on their overseas infrastructure and energy projects. Emma is an English qualified lawyer and during her career spent 2 years working in the in-house legal team of a major Japanese contractor. Emma, over to you.
Thank you very much, James. Well, I'm delighted to be joined today on my panel by Julian Bailey, who's a partner at White & Case in London, Angus Rankin, who's a partner at Hogan Lovells in London, Ewan McLean, a partner at BlackRock Expert Services, who regularly acts as a delay expert on disputes around the world, and Ben Goff, who's a data and technology lead for Mott MacDonald's Metro and Civils division. We have seen over the past few months since the pandemic hit an unprecedented embracement and harnessing of technology in construction. Some of this technology has been available and in use to a certain degree for some time, such as BIM and drones, but it's been the pandemic that has driven the need to use this technology on a basic level just to ensure the health and safety of workers to prevent infection. And indeed, we witnessed a similar rapid development and deployment of robot technology in the wake of the Fukushima disaster in 2011, when it was impossible to send humans into the reactors to assess damage and conduct vital stabilizing and clean up operations due to the high levels of radiation there. We're really now seeing owners and contractors focusing on releasing the potential of new technology to drive efficiencies and cost savings across the board on construction projects. Certainly, while many were aware of the potential in the developing technology, to a certain degree, the pandemic could be said to have acted as a catalyst to drive forward innovation far faster and more extensively than we might have otherwise expected even a year ago. On our panel today, we'll be looking at correlations between advances in technology and construction and what kind of impact this might have, not only on how projects are constructed and operated and maintained, but also on the nature and extent of claims that might arise during the course of a project and how those claims are presented to courts and tribunals. Importantly, how can we ensure that we harness technology and the data it produces to best effect? So Julian, if we can start with you, please. We heard Derek Nelson in the first session today explain how in his career as an expert, technology advancements have come on in leaps and bounds since the ruler and the abacus. The same could be said for the advance of technology in resolving construction disputes, couldn't it?
Thanks, Emma, you're absolutely right. And hopefully you can see my slides. Are they all there, Emma? Good, yes?
Yes,
great.
Absolutely.
Fantastic. Well, to give some background to what we're going to be looking at, I thought it'd be helpful to go through some of the history of how technology has been used in resolving construction and engineering disputes. So let's go back in time, shall we, to the 19th century and before that, and ask the question, well, how are disputes resolved in the good old days? And the answer was a very low-tech way, which was through the use of the jury system. 12 good men and true, as they said. So what did juries do? Well, juries took questions that were put to them by a judge, and based on the evidence they heard, they would give an answer to that question. So it could be, how much is the builder due? And they would give the answer, £25 or whatever it was. And this is all very, very low tech, and that was fine in its day. But things moved on, and things moved on in two ways. First of all, we saw the rise of trial by judge. So juries were phased out for civil cases, and that was due largely to practical matters. It was quite hard to get 12 people together, a fairly cumbersome procedure. And so you had judges who had fairly forensic minds coming in and deciding these cases. And judges have to give reasons for their decisions. They can't just say the builder's due £25. They have to explain why. So a bit of analysis was called for there. Now, at the same time, what we also saw was the introduction of new technology, including what you see on the slide. The camera was invented. Looks very low tech to us, but at the time, this was really cutting edge stuff, the photographic camera. And that was not invented for the court system, but it came to be used in the court system and is still used today to resolve construction disputes, as we all know. And to give you an illustration of what I think is actually the first construction case in which photographic evidence was referred to, let's go back to this case from 1875, which involved Lord Bateman, who you see on the left there, against the builder Thompson. Now, the case was about this building you see on the right called Shobden Court in Herefordshire in England, which no longer exists. It was either demolished or perhaps it fell down. We don't know exactly what happened there. But it may well have fallen down because the building was built in a fairly defective way. So the builder sued for money. Lord Bateman said, no, you're not due this money. In fact, you owe me money because the building is defective. And as part of the case, evidence was put before the court in photographic form. And this is what the judge in the Court of Appeal said in relation to that. So he said, it is found in the case that there have been improper materials used, and the photographs which have been laid before us, if one is at liberty to refer to them, show plainly that Lord Bateman has had put upon him an amount of work so utterly bad that must have occasioned him very just indignation and annoyance of mind. So you can see the judge recognised that the work was quite shoddy, but the judge was relying upon the photographs that had been put before the court, which showed the improper work. And so photographs were used in this case and have been used subsequently. Why was this technology so wonderful, and why is it still relevant to us? Well, there are a few reasons. The first one, of course, is it captures something at a particular moment in time. So if we have building work being done, we can take a photo of it. It might be built upon, or something might happen to cover it up. But we can see what it was like at a particular point. That's very useful as a record of what happened. And also, and this was particularly relevant in earlier times and more so today as well, it saves the court or whoever it was, the arbitrators, from going to the building site to look at the work. They didn't have to do that because they had photographs. So this technology has proved itself to be very useful in resolving construction disputes. Now, I want to go forward in time, more than 100 years, to the good old 1980s, when we had things like the personal computer being invented. You see one there on the left. And at the same time as the computers were invented, we had software being created, including an example of which you see on the right. This is Primavera. And Primavera and other forms of scheduling software changed the nature of construction projects from a planning perspective, because details of activities could be put into the computer in particular orders. The computer could tell you where the critical path was, and you could also change things around. You could move activities around and see what impact that would have. And this is all wonderful, and it was invented for people in industry, in the construction industry, to manage their projects better. But what you also found was you could use this technology in the courtroom and in arbitrations. But because of its highly specialized nature, and it takes a real expert to use this software, we saw the rise of a certain type of expert. And there's a picture of one on the slide, handsome devil. That's Ewan McLean, you'll be hearing from in a few moments. But he is an expert in delay evidence. And so courts now need to be, and arbitrators need to be assisted by people who are experts in how to use this particular software, because it's beyond the means of many people, myself included. So how has this development in technology been received in the courtroom and in arbitration? Is it good? I'd say generally it's an improvement, certainly, because it gives us a fairly good way of analysing delay, and we can come up with fairly precise analyses of delay as well. We don't have to pluck a figure from the air as to how long a delay was. The computer can help us work it out. But this has not come without its complications, because we see regularly problems when it comes to delay expert evidence. What are those problems? Well, one example is agreement between the experts over what the baseline program is. Sometimes the experts agree, but often they don't. Secondly, we also know that the quality of what comes out of the computer analysis depends on what goes in. So garbage in, garbage out. There can be issues there. A further issue, which I think applies almost universally now, certainly for larger disputes, is data overload. There's a lot of information that goes into this, and it's quite common to see delay expert reports run to hundreds of pages, often giving detailed narrative of what happened on the project day by day. And this is a lot of information to deal with, and takes time and therefore costs a lot of money to deal with too. Other problems include lack of standardization for delay analysis. We pick up the SCL protocol, we pick up the American AACE protocol. They give us a menu of options for analysing delay. Which one should apply? Well, there can be disagreement on that. And on top of all this, we can have huge scope for subjectivity creeping into delay analysis. So one party might manipulate things to suit its case, and the other side might do the same. And this can in fact create disputes rather than narrow them. Another possibility as well is that the computer is trusted to give us the right answer. So we plug data in, we get an answer, but no one knows why it's right or whether it's wrong. And that in itself can give rise to further forensic issues. So what I suggest is that although overall this new technology in relation to delay has helped us, it's also given rise to a number of issues which previously we didn't have to deal with. So the technology has been good, but possibly we've created a monster, a bit like Dr. Frankenstein's creation there on the slide. So what I'm saying is that for any new technology that comes along, the way it has to be understood and tested as to whether we should use it is whether it's going to help us deal with construction disputes in a more efficient way. We can deal with things in a fairly rough and ready way as under the jury system, or we can take a fairly scientific and very fact-sensitive approach using Primavera and other approaches. But ultimately, we need to ensure that there's some kind of efficiency working there. And this is made paramount, it's made very clear under the rules of court in most countries. You can see here the example from the English court rules, which say that the rules are a procedural code with the overriding objective of enabling the court to deal with cases justly and at proportionate cost. So time and money are relevant here. Similarly, with arbitration rules, we see a similar sentiment expressed. So tribunals and parties shall make every effort to conduct the arbitration in an expeditious and cost-effective manner. Those are very key considerations here. We're not on a search for the truth. We're not on the search for the right answer to the nth degree. We need to come up with an answer that is fair, that is just, but we need cost and time efficiency too. So let me conclude by saying that when it comes to new technologies, yes, there's a lot for us to look at, and there are new possibilities here. There may be great things ahead, but for this technology to help us in resolving construction disputes, it needs to be such that it helps us to get to the answer in a time and cost efficient way. So I'll end there and hand back to Emma.
Thank you very much. Thank you very much. So if we could turn to Angus, please. Julian has touched on technology as it relates to the process of resolving disputes. Angus, could you share some litigators' thoughts as to technology forming part of the permanent works themselves?
Sure, thanks, Emma. Yes, I certainly don't want to be your Luddite or your glass half empty guest on this panel, but I think it's worth considering some of the difficulties that the new technology could entail within the project itself, not just as a dispute resolution tool. As Julian has just touched on in the context of critical path analysis and other tools, any human endeavor is subject to human error, and of course engineering errors are often writ large. And I think that human error element in engineering is going to be with us for the foreseeable future. Although how long it will be with us is an interesting question, perhaps for another day. The errors, the things that can go wrong with new technology is in one sense an invitation for things to go wrong. And as we all know, when things go wrong, that can range on a spectrum from blemishes, cosmetic things, which are merely irritating in an industrial project, but could actually significantly diminish the value of other kinds of assets like residential or retail. Especially at the higher end. And then at the other end of the extreme, of course, we see technology in the most severe realm of fatal accidents and environmental damage. And we're seeing entire industry sectors, one of which would be waste to energy, a sector that I'm involved in quite closely, really being bedeviled in many cases by some of the challenges that the more innovative combustion systems bring with them. And we've seen several large contractors in that space actually brought down principally as a result of the technical challenges of those projects, particularly when you're dealing with a very variable feedstock. But look, all structures could be built many times stronger and more durable than they are. And I suppose this is the balancing act that gives rise to the issue. You can build things stronger, but that comes at a tremendous cost and possibly some loss of functionality. And excessive strength is uneconomical. So the question then arises, how strong is strong enough? And it's not always easy to tell where innovation is going to lead to success or failure. Let me just briefly take the example of a structural failure. We know that the majority of structural failures result from cracks forming over time. And our own Houses of Parliament here in London, Big Ben, famously broke when its bells were struck for about the 4 millionth time in the 1970s as a result of cracks that had been propagating since takeover in the 1800s. The question, of course, and where the technical and the legal interface in an interesting way is, how fast do those cracks grow and how fast does material degrade relative to the asset's expected life, but also relative to the expected maintenance intervals for the asset? And where does all that sit alongside the contracting team's legal liability for patent and latent defects? Because the challenge, as we've seen, of course, is that you can't generally do real-time, full-scale fatigue experiments, and the full-size model of the structure is actually more often than not going to be the finished project itself. That gives rise to a risk that lifetime will not be achieved. And it's usually one of the livelier topics that we tend to see in contract negotiations, giving rise to the sort of issues that we saw in play in the MT Hogarth case. An MT Hogarth case, which looked at a 20-year design life, was also interesting because you saw there the flawed offshore wind industry standard J101 as a very good example of an industry very much having to learn from its mistakes, unfortunately live, across an installed base of projects and not just in the test laboratory. I've mentioned the element of human error. Now, I think to some degree, as Julian's already touched on, computing power is probably a double-edged sword. It brings huge advances in terms of the complexity of calculations that can be done, but also by introducing greater complexity and more automated processes, it may be harder to notice things which are suspicious or wrong in the design. And perhaps the rest of the panel would like to pick up, if you like, arguing technology's case the other way, that things like BIM, however, may help us to mitigate the very risks that automation brings with it. But I think it's fair to say that computers are probably a source of overconfidence on the part of their human bosses. Just think, for example, about what still gets through on a spell check in Microsoft Word, for example. Now, I read somewhere that most engineering failures result from ignorance, carelessness, or greed. There's probably a degree of truth in that, harsh as it may sound. But what is clear is the very difficult balancing act that the designer or provider of new technology has to navigate at common law and under the kinds of contract terms that we deal with. And picking up on just a few of those points quickly, and very much from my own English and common law perspective, of course, the manufacturer may still be bound by his bargain, even though he can show unanticipated difficulty or even impossibility. And as in the MT Hogard case, which I've just mentioned, you may be held to the higher of multiple conflicting standards stated in the contract. And where we're dealing with the very latest technology, the body of industry knowledge against which you're being judged as professionally negligent or not, that body of knowledge may be relatively small. Further compounding the tightrope, of course, that technology providers have to navigate, and designers, we of course see cases not only where the complaint is that something has been under-designed, but also going the other way, that something has been over-designed, such as in the London Underground and Kensington Ford case, where the issue of whether the slab over the station concourse could have been thinner and cheaper. And I think whenever we're talking about new technology, it's worth bearing in mind the difficulties that you may have in advancing a so-called state-of-the-art defense. There are those old 19th century cases like Turner and Garland, but I think the position today is more likely to be as in IBA and EMI, that even pioneers must be prudent. So innovation, rather than decreasing the onus on you, would rather place a greater onus on you. I had a few more points to make in that area, Emma, but perhaps I should hand back to you.
Yes, well, I think we've still got a little bit of time, but I'd be interested in your thoughts, if I may, on the role that technology might play in the early identification of faults in the works, and some of the issues that might arise out of that.
Sure. Well, I think other panelists are probably much more tech savvy than I am. But I think one way into that, or one way of looking at that, might be through the Internet of Things. And I think that probably has a rapidly expanding role to play in predicting, basically monitoring assets and predicting problems before they occur. Emma, I know you and I have both trod quite similar paths and worked in power generation in that sector a lot. I mean, the power sector has been doing this for years, covering gas turbines in remote monitoring sensors in an effort to diagnose failure and try to preempt it before a catastrophic failure. And it will be interesting when that approach gets transposed, I think, onto different systems.
Absolutely, and we can see that that's one of the intentions. We can see that's one of the intentions of smart cities as well, isn't it? Mm-hmm. So it has huge potential, I think. But will it all be good, do you think, or?
It's a bit like Chairman Mao and the French Revolution. Too early to tell. Well, this certainly is too early to tell. But I suppose my final comment on this is that I think where you get into predictions of failure, I think that could give rise to really interesting questions of liability, because you may be remediating something based not on actual failure, but predictions of failure, and who should bear the costs of something that's really a hypothetical failure. And as the monitoring improves and can maybe look further into the future, is that then going to sort of beef up your exposure to a design life obligation? Because even within your 24-month warranty period, let's say, as in Hogard, the diagnostic is looking ever further and further beyond that period. But that's an argument for another day.
Well, those are certainly very good points. Thank you very much, Angus.
Thanks.
Now, Ben, please could you outline for us your insights on harvesting the right data, both now and what use he is to come in the future?
Of course. So we've heard quite a bit about sort of new technology, and in particular that how that's giving our projects, an increased digital footprint. But we've got to remember that construction is an industry which is rooted deeply in the physical. So we need an interface between that digital and the physical realm, and that's where data capture comes in. And we need to make sure we're obtaining the right information to support our decisions, manage our risk better, and generally get better outcomes to, hopefully in my case, avoid disputes, but also settle them better. So I'm going to give a really quick run through of where the state of the technology is and some of the issues we really need to be aware of when we're trying to get this right information. So when I talk about right information, what I'm thinking is I need to get the right data in the right format at the right time to the right person, and I need to be able to do all of that safely. So if we're thinking about the right data, so we can start thinking about sensor types. So we've got our very traditional sensors. This might be measuring accelerations, pressures, temperatures, whatever we're thinking of. They're generally getting cheaper and more robust. And as Angus mentioned, the connectivity is really coming in, particularly with 5G applications. So we have an Internet of Things. We can start managing and collecting data on greater scales. We also have our imaging technologies. So we have our traditional photography, but we can actually go beyond what our eyes can see. So we can start looking at applications like thermal imagery, in this case looking at for underground water leaks in embankments using thermal cameras. We can even go further than that into multispectral and hyperspectral. So on the left is an example of finding invasive plant species using multispectral photography, and on the right is detecting contaminated ground on site using hyperspectral imagery. We've also got technologies such as LiDAR, so this detection and ranging, so using laser measurement to build really, really accurate 3D models of what we're dealing with and building. But we can also start looking below the surface. So this is an example of ground penetrating radar. So we can look underground or even within our structural elements to see what's actually happening inside. We also have all sorts of other contextual things we can start picking up. So some projects we may need to monitor for gas or radiation, or look at environmental effects like weather and noise, and even electromagnetic interference. But for every single one of these sensors, we need to make sure that it's in the right position to gather the data. So some sensors, we're a bit limited. We have to fix them in place. It's fine for these sensors, but it really limits the ability to scale. The more we want to monitor, the more sensors we need, and cost rises very much linearly with that. It also, typically, we don't get these sensors in place until we've built the asset. So we don't get much of a picture of how the asset came to be, which is usually a very key element in a lot of disputes. So to come over some of these issues, we can look at transient sensors. So it's making a sensor where it's putting it in the right place at certain times, and that can be as simple as just a man on site with a camera or a piece of survey equipment. But in the industry, trying to do things more efficiently and safer, we're turning much more to essentially advanced robotics. So it may be aerial drones loaded with sensors. It could be underwater vehicles for offshore applications, or even this wonderful robot dog that Boston Dynamics has developed and is now entering the industry, all of which can be loaded with sensors, get those sensors to the right place when you need them, and capture your data. But once we've captured the data, we need to understand how we get value out of it. So that's getting it in the right format. From this typical sort of 2D photo, the raw data, I can identify certain things, but it's very manual, it's labor intensive, it's very limited in what I can do with it. But if I take a whole series of these images taken in a structured way, I can use photogrammetry techniques, for example, to turn it into a 3D model, very highly realistic. I can also start taking accurate measurements from that model. I can integrate that into all of my design data and compare what's actually happening on site with what we have assumed and designed for, to start picking up issues earlier on in the process. And beyond that, we can start layering intelligence onto the top of these processes. So that may be looking at change detection. So this is an example of Network Rail using aerial LiDAR to pick up changes in slopes or vegetation. But it could be automatically recognizing features as we build them and assuring them against an as-built 4D BIM model. When we're looking at the right time, if we have fixed sensors, we generally have continuous monitoring, so we know exactly when something happens or changes. But if we're looking at transient sensors, we have to settle for discrete snapshots. So we need to make sure they're regular enough to give us current data to make our decisions at the time, and also to provide robust enough records to defend those decisions should they ever be questioned in the future. But for both, we need to make sure that our data is accurate, so it needs to be repeatable. This is just an example of the effect that a bit of buffeting wind can have on the quality of data coming in from drones. So we really need to understand the technology and its limitations deeply when we plan for these things, to make sure that what we get is useful and going to be valuable both during the delivery and in the future. We also, when we look at the sort of getting the data to the right person, so we have to think about elements of ownership and sharing. So who owns and manages and monitors the data, and how it's shared, particularly in terms of how it goes on to third parties for future usage and how liability flows with that. We need to understand how we bring together the right information with the right domain expertise to get actual valuable insights that help us make the right decisions. And particularly now that we're starting to gather more and more data, we may have decision support tools which may be data analytics, it may be machine learning, all sorts of new techniques, and we need really robust processes in place to make sure that we can verify and validate those models. But also it needs to be very highly transparent and objective to make sure that the trust between all parties on the outputs of these tools, how they're being used and the data that's going in is well understood, because otherwise they become a black box and no one can really understand why we've done what we've done. So just switching on to future trends, we're seeing both sensors and platforms, the capabilities of these things are continually rising and the costs are dropping. So it means we can know more, and the cost of knowing more is becoming more and more marginal compared to the value we can create from this. So it's going to happen more. Miniaturization and autonomy, again, it's allowing us to do more, access more spaces more safely with greater control and consistency, but also potentially scale up our operations, get big step changes in what we're collecting for relatively incremental cost increases. And then the regulation, it's generally a break, and so are the industry standards. They're racing to catch up. I've had the opportunity to contribute to industry guidance on the use of drones in industry, and also our contractual models, particularly around persistence of data through the capital and operational phases of projects, is a very tricky one that needs addressing. So if there's one thing I'd want people to take away, it's that there's really great opportunity here, but to use it and not essentially use it just to muddy the water, it needs to be really carefully planned, not bolted on after the fact, and bring together the right mix of technology and technical expertise. And I think that's it from me, really.
Okay, thank you very much, Ben. I mean, I would just add there, I can see a cynical contractor saying, I would rather not be harvesting quite so much data about exactly what's happening on site. They have their reporting requirements specified in the contracts, and they'd like to stick with those to the slimmest degree possible. But maybe, yes, I am being too cynical there.
I think it's where the more collaborative contract models really start to come into play, and particularly all the way through our supply chains, not just our clients and tier one contractors.
Yeah, I think that's fair enough. Thank you. Well, look, I'm going to turn now finally to Julian. From your perspective as a delay expert, with huge amount of experience of presenting expert programming evidence in arbitrations around the world. Could you touch on how advancements in technology are going to impact construction sites and owner and contractors' expectations of executing projects, but also in presenting delay analysis to tribunals? And in that respect, on the last comment, I have been noting the questions that are coming in, and so I will look to direct a few of those to you, Ewan, during your presentation.
Yes, surely. Well, firstly, thank you, Emma, and good day, everybody. I will certainly attempt to do all that. But the first question really is, will new technology mean there are fewer disputes in the construction industry in the future? And I believe that on balance, it is likely that there will be fewer traditional disputes, at least. So this will be pleasing to hear for all those members of the construction industry, but perhaps less so for the legal industry. But why is that? Well, it's because new technology like BIM, VR and AR, robots, 3D printing, etc. will improve productivity, efficiency and site safety. Okay, but how is this technology actually going to improve productivity, efficiency and safety? Well, on site, technologies such as robots, autonomous vehicles, 3D printers and drones can work 24 hours a day, increasing output, not become fatigued, maintaining better rates of productivity for longer, have the necessary skill set addressing any particular skill shortages, have a higher degree of accuracy, eliminating human errors and defects, thus improving efficiency with less free work. They can carry out tasks that are dangerous, improving site safety, and they can cooperate in all sorts of weather conditions, making sites less prone to weather delays. So along with BIM, VR and AR, management can also make better decisions with better data produced in real time and address issues earlier. And these decisions can also take account of historical as-built data and norms and actually improve communications and understanding between parties, avoiding disputes. Consequently, there'll be a greater certainty in delivering construction projects on time and to budget with less disputes. But I give a health warning there because employers will expect their projects to be delivered earlier. Turning to disputes and evidence, and in particular delay disputes, programs currently usually target the best case scenario rather than the most likely or realistic scenario, meaning projects can be orientated towards failure from the outset. However, technology will improve this perhaps hopeless optimism, since it is based upon hard data improving the quality of programs and progress reporting. Now, currently when communicating with parties or tribunals, I often see programs like this saying, here's the critical path. Well, I consider these sorts of programs as unhelpful and really unintelligible to non-technical audiences, as they clearly don't set out the critical path with clarity. In addition, people are bored by this sort of presentation, and a compelling presentation is more likely to be persuasive. And people also don't want to read everything, and they prefer to watch. But technology now means that programs can be presented in a more compelling way with the use of BIM, VR, AR, and video. So what is BIM? Well, BIM enables project teams to move through their construction project programs in an immersive virtual space, i.e. the structure or the site, seeing how works will develop before they actually occur on site. And BIM can provide a visualization for site teams ahead of the work to be carried out, making them more efficient when the work is done, provide the ability to detect physical clashes on site, as well as the ability to detect sequence clashes in programs. It allows proactive project management, reduces changes, produces data in real time, as well as the possibility of simulating alternative scenarios. And again, this should all reduce disputes between parties. And where disputes are unavoidable, assist tribunals in their understanding of complex construction issues. So with some more time, I would have shown you a 4D program visualization, but in the time available, I've shown here snapshots from 4D animations, which allow parties or tribunals to see what was actually happening at a particular point in time by reference to a 3D visualization of the project. For me, it brings the data to life and it's much more understandable. So this may mean the traditional role of a delay expert is going to be challenged, and they'll need to upskill and transform into visual communication experts. Nevertheless, it's important to note that construction expertise will still be required because a visual does not in itself identify a critical sequence of works. But are we actually going to solve problems and deliver projects more quickly without delay, or are we just going to document the car crash better? Well, technology is going to assist in avoiding historical issues that have plagued the construction industry, and I've provided a few examples here, but just speaking of one, the connected job site will mean contractors with, say, several sites in one city can communicate between sites in real time, sharing equipment that has not been used at one site that could be used at another, thereby improving productivity and efficiency at both sites. And again, this should lead to fewer disputes, but some disputes are unavoidable and will end up in front of a tribunal. And in this event, the quality of data should assist the tribunal's understanding, as they'll be able to review the project as if at site and at the time. As we've seen, the 4D models will allow the tribunal to actually visualize issues rather than have 2D drawings and flipping Gantt charts explained to them from a technical perspective. Indeed, technology should reduce the subjectivity of disputes, since we are approaching the time when we can sort of rewind the case to see what actually happened. Of course, a common criticism of new technology is rubbish in and equals rubbish out, as Julian referred to. Therefore, there'll still be a role for a delay expert to test the veracity of the evidence presented, but even here, real-time data can be leveraged to assist in checking what is claimed actually happened. Also, the volume of data or evidence to be considered is going to increase dramatically, and that volume of data will still need to be disentangled into simple presentations to assist tribunals. Indeed, as noted earlier, the delay expert is going to have to upskill to become a construction and technology savvy expert. And technology may also result in current delay analysis methodologies losing favour, as say retrospective analyses relying on what actually happened are preferred over prospective analyses. So in summary, the main benefits to the construction industry of accepting technology are likely to be an increase in productivity, efficiency and site safety, a greater certainty in delivering on time and with less cost, the production of evidence and dispute resolution, possibly avoiding some disputes, but assisting tribunals in their understanding. And Max Abraham famously said, a party to a dispute, particularly if there is an arbitration, will learn 3 lessons, often too late. The importance of records, the importance of records, and the importance of records. Well, now we have them. So all this technology will produce data from which we will be able to make better decisions and provide better evidence in arbitration. So just very briefly, looking to the future, technology will mean the creation of new jobs such as robotic managers and drone managers, or as I prefer to call them, drone rangers. It is likely to reduce the number of projects delayed. It's likely to impact the type of delay analysis carried out. It's likely to lead to more off-site work or prefabrication. And we're going to have the ability to rewind the case to see what actually happened. So therefore, the role of the delay expert will be challenged, and there will be a need to adopt IT skills to be able to assimilate and present to the court data in a clear, coherent manner. So delay experts will need to be visual communication experts. Thank you.
Ewan, thank you very much, and thanks to Emma for chairing a fascinating session, and thanks to all of her panelists. We've run slightly over time. I'm quite sure that Emma and all of her panelists will be more than happy to answer the questions that have been raised in the Q&A. Their details are splashed all over their law firm or a company website, so I'm sure you can get hold of them easily enough. Thank you very much, Emma and panel.